intentionally.
Oh, I
Okay.
appreciate that.
Okay, we got all zeros showing, so I think we can start now. Please
Okay, thank
proceed.
you. Yes, Your Honor. So this is an appeal from an order of dismissal with prejudice on a motion to dismiss. And it's a case where it was filed on, I think, in June, I think June 24th. And it was a case for declaratory action and eviction, or non-lawful eviction and conversion of property. On July 15th at 6:40 in the morning, Mr. Kangas sent an email over to Judge Cook's JA and requested, pursuant to an administrative order, that they dismiss the case without a hearing. Now, it's under an administrative order, which we actually attached as a into the appendix. And if you look at it, it's 11C, and it's on page 7 of that tab 2. And it states that a non-evidentiary pretrial motion may be ruled without a hearing. And what you have to do is you have to send an email, but then you have 10 days to respond. Uh, the uh, the appellant would have had 10 days to respond under this administrative order. That email was sent to Judge Martha Cook's JA at 6:40 in the morning, and before 11 o'clock, less than 5 hours later, Judge Cook dismisses the case with prejudice. Um, this court has said in numerous cases, including TL Justice FM, that due process needed to be afforded, and there was no due process afforded because the appellant had the right to make an argument as to why the case shouldn't be dismissed.
So
But
let me ask you, I'm trying to understand where you're going with that. Do you say you're entitled to due process, which I don't think anyone would disagree, but do you say due process is automatic and presumed, or does due process require some showing of prejudice, and was that made?
I believe due process is owing, and I don't even think you need prejudice. I think you have to follow the law. And I think the Supreme Court has been very clear in the pivotal cases of
Well, when you say
2020.
follow the law, you're talking about the administrative
They didn't even
order?
file they didn't file the administrative order. I think the administrative order has some due process issues, but that's not the point here today. What the point is that the administrative order gave 10 days, not 5 hours. There was no time to even respond to the motion to dismiss. Does that
So
answer your question?
so the remedy you're seeking is a reversal to go back for 10 days to expire before the judge can enter an order?
No, Your Honor, it should be the motion to dismiss should be reversed and proceed on the case. And the reason that the appellees don't want the case is because they don't want to go into the evidence or have their depositions taken because they're traveling under some false orders and some other stuff that we've uncovered. So that would be the appropriate remedy, is to reverse the motion to dismiss so that we can go and proceed on the matter. But due process never even came into the picture here. And I believe the Florida Supreme Court, in following Scalia and the textualist approach, is very clear that the judiciary does not get to change, administrative orders, the Constitution, and the legislature's statutes, the statutes that the legislature enacts. And I think the pivotal cases start with the in re to the Amendment 4, January 16, 2020, State versus Poole, which is an excellent case, a 57-page case, which really explains what the courts need to do. And that was decided January 23rd, 2020. And the crowning case on that would be Thompson versus DeSantis, which is only a 3-page case, but really hits the nail on the head that the courts must follow the law. And in this case, the law has never been followed. Homestead property, which Mr. Kangas is going to argue, says, oh, he can take it. Well, no, he can't. Homestead property was taken as a sanction in violation of Constitution. It's been violation of Article 4, Section 10. And there has never been a hearing on any of that matter. And he is also wrong and misrepresented the law in Homestead, because it talks about how homestead property has to be just the owner. No, In re Alia and the Beltran case basically say, no, as long as it's a family relationship, homestead attaches. So Mr. Sussman had the homestead protection. And so his arguments in his reply brief are false. But you go back to that administrative order. There had to be due process. That is an ex parte order. And ex parte orders are suspect in, for one thing, and it's ex parte because Bayview Loan Servicing, which is noted in the brief, because I can't say the second name, it's disastrous. And it says that you are entitled to due process. And entering a order without an opportunity to be heard is a severe violation of due process.
So did your client have an opportunity to eventually say what he would have said had he been given the 10 days to reply when the motion for reconsideration was filed?
No, there was no opportunity. So
Did
there
she
was a
file a
motion for,
pleading? Did she assert the prejudice or the response that would have been filed?
the client never was able to, he filed a motion for reconsideration, but the court just stuck with its guns. That was done within 3 days. There was no opportunity to be heard. And that is the key pivotal. And I think the Florida Supreme Court is very clear on that in terms of its textualist approach. Again, I think that there are some issues with that administrative order, just having a dismissal without a hearing. But that's not even the point. We never even got to that. We net 5 hours and they dismissed the case. And again, the courts have said that type of ex parte communication, or ex parte, because it is ex parte, only one side got to present arguments. And that's where the Bayview case is very pivotal and says, no, you have to have due process. Due process and an opportunity to be heard. And the Constitution has been violated in this case. And those are the issues that need to be presented. Those really aren't seminal for today. They're not important for today. The most important thing is the due process rights of the appellant were denied because there was no opportunity to be heard. And the judge just sui sponte dismissed the case without that. And unfortunately, that's not how the Constitution, the state of Florida works. People have a right to be heard. That's our beautiful system of justice. And so that's where we are. That's the most beautiful part. We are a nation of laws, not people, but we have to follow them. We don't get to change the law because you don't like the appellant. Just because you don't like the appellant doesn't mean you can't follow the law. And I think that was appropriate in State versus James. It was an excellent opinion decided, I think, last year from the Second District Court of Appeal. And no one would like the appellee in that case, but the law was followed. And that is what the Supreme Court, I think last year's last year's amazing cases that come out saying the textualist approach is going to be followed means the rule of law is going to be followed. And if it says you give 10 days to have some kind of response, you get 10 days. And that is the system. So for the court to not reverse the lower court decision really would be in violation of the Scalia textualist approach that this Florida Supreme Court has really taken as its mainstay to the DCAs. So, and then the other argument that Mr. Kangas makes is that it was not a landlord tenant. Well, it was an unlawful eviction. And Mr. Kangas tried to, in the lower court cases, massage the case and say, oh, it was an eviction landlord tenant. No, it wasn't. It was homestead property paid for by the owner of the property, and the courts unlawfully took it as a sanction. And that is in violation of Article 10, Section 4 of the Florida Constitution. There is no getting around that. It is a violation. And but we're not at that point. Those are his arguments, but those arguments aren't relevant for today, because the most important thing is there needed to be an opportunity to be heard. The appellant had a right to make an objection. That isn't just his opinion. It's not just the case law. It's in the administrative order. Within 10 days, he had the right to make an objection, and no objection was allowed. You can't make an objection in less than 5 hours. Something filed at 6:40 and by 11:20, it's dismissed. That doesn't give anyone the due process that they're entitled to when you're dealing with homestead property, because homestead property is sacrosanct in this country. It's Beltran versus that we quote in the brief says it right there. Havico says it, but Butterworth all say it. The most important thing is the preservation of the homestead property, which has not been done in this case. And there are other things, but they are not at this time relevant for the argument, because the most important argument is the due process issues of the fact that there was no opportunity to be heard. And the other thing is there were valid causes of action that should have been heard, and there should have been an opportunity to do that. If we're going to do and just decide that a judge's dismissed case, that becomes judicial fiat and judicial tyranny, which the people of the United States, the people of the state of Florida, have never asked for. And that's why we have a fantastic constitution. We have a legislature that just finished their session. They enact the laws. This administrative order is pursuant to an order believed from the Chief Judge of the 13th Judicial Circuit. But it is, if they're going to use it, we have to follow it. We can't change it because you all don't like who the appellant is. You have to follow what the administrative order. If you're going to claim that as the basis for dismissing a case without a hearing, without due process, without an opportunity to be heard, you have to follow it to the T. And if you don't, that's judicial fiat. And that's why the case must be reversed. This is one of those cases, there's no discretion because the law has to be followed. And I think that was the message out of Thompson versus DeSantis, and an excellent opinion cited September 11th, actually 2020, where it says we must follow the law. Whether you like the law or not, whether you like the administrative order or not, you have to follow what's presented for you. You just can't change it because you want to. And when an order is entered where there is no opportunity to be heard, that's called ex parte. And that is the most grotesque form of due process violation, because that's one side getting to do whatever they want. And that's not what our system is based on. Our system is based on of checks and balances, the legislature, judicial, and executive. And in this case, all of those are being violated. So we really want to make sure this is not a case, and it tinges on Hazel Atwood versus Hartford Empire, where you want to sit there and say, it's not just one case, it's the public, what it does to the public. So if a judge can go in and say, I'm not going to follow that administrative order, I'm not going to follow the Constitution, I'm not going to follow the law, then we have violated the whole public trust, and we have violated our system of laws and checks and balances. And that is where we're going. And again, Mr. Kangas tries to say this was a landlord-tenant. He tried to massage it as a landlord-tenant, but it wasn't. It was homestead property unlawfully confiscated based on a faulty order, a false order that has never been presented. And his whole end game is to blunt the ability for the appellant to get discovery, because discovery will be illuminating because of all the sworn statements we have taken under sworn statements under oath that contradict everything that Mr. Kangas has done. So that is what's really important. And so they're using this as an ability to block the appellant from having his day in court. And that is not what our system is based on. And so we really want to make sure that due process is followed. And the due process is the most important thing. And we are afforded an opportunity to be heard. And when it comes to Homestead, he's misquoted the law, as I said. And in Homestead, it's sacrosanct. And you cannot take homestead property. There has never been an adjudication of homestead. Mr. Kangas likes to cite to a case that you all PCA'd, but the case is based on the fact that Judge Barber said I could never be fair and dismisses the case. That case was incorrectly decided. And I think that goes back to State versus Poole, decided January 23rd, 2020 in the Florida Supreme Court, which talks about if there is a mistake in law in not following it, those are not precedential, but areas that need to be of concern, because homestead under Article 10, Section 4 cannot be changed by the legislature, by the judiciary, but it can only be changed by an amendment to the Constitution. And that has been upheld up to the 11th Circuit in Havico, and it's come back down. And I think that is the key to all of these cases. So that's his argument. Oh, they're not entitled to homestead. There has never been a hearing on homestead. Due process has been denied throughout the cases. And that is one of the issues that is so important in this matter, is that due process be followed and that the administrative order be followed, and at least have the 10 days to argue. But more importantly, I think in front of a judge in an argument, the case would never have been dismissed. And I'm just going to reserve my 5 minutes for the end.
Thank you, counsel.
Your
Mr.
mic is
Kangas,
muted.
okay, you have unmuted. Good. We are ready to begin your presentation.
May it please the court, counsel. This appeal arises out of a lower court case, which is the latest in a series of cases filed by the Sussman family trying to avoid a final judgment that was entered in the 13th Circuit back in 2017. And I think that became very apparent in Ms. Gaffney's argument today, where she says that case was incorrectly decided. We've got a affirmative.
That case is not before us, although it's probably before earlier panels.
I
might have even been on one of those panels. My question today is the procedural aspect that has been raised by the appellant. The appellant argues that under the administrative rule, 11C entitled Other Non-Evidentiary Pretrial Motions, there is a provision in there that reads, if no objection is filed within 10 days of the request stating good cause why hearing on the motion should be granted, the court will rule on the motion without a hearing or direct that a hearing be scheduled. It's the initial part that I'm concerned of in light of the allegations. Counsel says that the motion was filed and considerably short of 10 hours later, a ruling was forthcoming. If the trial court is relying upon this administrative rule, why was it not followed?
I don't know why it was not followed, Your Honor, but if you look at,
Do we agree that it wasn't followed?
I would agree that that rule is not completely followed, Your Honor.
Okay, and was it and does it apply to your request?
Could you clarify the question for me, Your
You
Honor?
filed the motion for a particular motion to dismiss, if I recall correctly. So does this rule apply to your request of the court to issue an order?
Well, the rule allows the court to rule without a hearing. I think under Florida.
That's what we're talking about. That's the
Yes.
rule, non-evidentiary hearing to whether to avoid a hearing. So if this applies and the court didn't follow its own rule, it would seem that the 10 hours is to provide a framework within due process. And it would not have been arguably followed if it's entered in a few minutes later or whatever time frame it was. And the prejudice would be there was an order dismissing. So my concern is the procedural due process that was afforded in this case. It would seem to me, and as Judge Spleet pointed out in the last hearing, all three of us have been trial judges at one point or another in our careers. And it's important that we follow the rules that govern our determinations. I'm concerned, that the rule was not followed, and I don't see any reason on our record why the trial court failed to follow it.
Well, Your Honor, I think you also have to rely on the case law governing due process. And this court has held, the second DCA held in the Carmona v. Walmart stores, that due process does not lend itself to a single unchanging test. Instead, they must consider the facts of the particular case to determine whether the parties have been accorded what state and federal constitutions demand. And
But it would appear that the chief judge in this circuit determined that due process at least afforded 10 hours.
Well, I respectfully disagree.
That's a fact, isn't it?
I think that's
This
a
order
guide.
exists, that it sets forth a rule. Isn't that a fact? Like
Well,
Carmona says, look to the facts.
I think there's a difference between an administrative order, Your Honor, and a court rule. The court rules are only promulgated by the Supreme Court. There is no right to a hearing in any case unless it's provided for in the rules. And with a motion dismissed, there is no right to a hearing. And in this case, the allegations upon which that dismissal was granted appear on the face of the pleading. Mr. Sussman never owned any interest in the real property.
My concern is not upon the ultimate result. That may be correct. The concern I have is that appellant was not afforded an opportunity to respond and perhaps present argument.
Well, subsequent to the dismissal, he did file a motion for reconsideration, which he raised his argument as to why he would be entitled to a hearing or should have been entitled to a hearing and what he would have raised at that point.
And that's
the
response to what Judge Vellante inquired about earlier, is it not? That something happened?
Yes, Your Honor. At record at page 28, Mr. Sussman filed a motion for reconsideration shortly after the entry of the order, where he raised his arguments. And the judge, in considering that motion and denying it, must have considered those arguments. And, the way I look at it is that response or the objection to no hearing, it did come within the 10 days. The court, if you file that objection on the second day, you don't have to give another 8. The court considered their arguments in that motion for reconsideration and denied them, rightfully so.
Mr. Kangas, let me understand what you're saying. You're saying this is not a rule of procedure. This is an administrative rule. Arguably, it blatantly was violated. So the question becomes, is there a remedy? And is the remedy limited to some sort of complaint to the chief judge about the judge not waiting the 10 days because it's administrative rule? That's not really emanating from a due process considerations of the Constitution or a state court rule, but simply a local administrative rule. But was it compensated for in connection with the rehearing, and was prejudice required to be shown? You didn't give me the full 10 days. I would have said X, Y, or Z. And if they had an opportunity to say what they wanted to say, and the judge said, you still lose, do we have a complaint on due process, or a complaint that there's a disagreement with the ruling?
I would agree with the latter with that, Judge. I think that the issue here is that they have a period of time to raise the reasons why a hearing should be had. The court obviously felt that no hearing was necessary because of the expediency with which the order was entered. But subsequently, a motion for reconsideration was filed, wherein any arguments that should have been raised or could have been raised could have been put in there, and the court denied that. So the court considered that objection or the response to the motion dismissed at that time and denied it at the second time. Now we're up here on appeal, and there's still not a valid reason to avoid the motion to dismiss raised before this court. And if the court is to reverse, we're going to end up back in this trial court making the same arguments with a dismissal with prejudice, and all it's going to be is causing delay. And I think we've got to look at the Massey v. Charlotte County case, where there's three factors the courts need to consider whether there was a violation of due process. What was the private interest affected? The second is the risk of erroneous deprivation of an interest through procedures used in the probable value, if any, of additional or substitute safeguards. There isn't any value to going back down there because we're going to end up back here because the substantive arguments on their behalf fail. And the third is the government's interests, including the function involved and the fiscal and administrative burdens that the additional and substitutive procedural requirements would entail. And here we are. This is probably the 20th to 25th, somewhere in that range, appeal of these same facts, granted filed by another plaintiff. We've got 4 case numbers in the lower court. We had a bankruptcy case that went to the Middle District of Florida up to the 11th Circuit. I would submit to this court that the plaintiff and his family have received all of the process that's due to them at this point.
Well, I understand what you're saying about the history of the case, but that's neither here nor there for us as we focus on this. My question would be on the motion for reconsideration. It appears that the plaintiff Sussman set forth all of their arguments in response to the motion to dismiss, and also alleged that the court violated the administrative order. They didn't ask for a hearing of the motion for reconsideration, and I don't see an administrative rule that applies to motions for reconsideration. So are you saying basically, even though the court may have not complied with the administrative order with your motion to dismiss, the court did comply with the motion for reconsideration and considered the merits?
That's exactly what my argument is today, Judge.
Okay.
If the court has no other questions for me, I'd yield the rest of my time back.
Thank you, counsel. Stop. The time clock is cleared. You have your 5 remaining minutes, counsel.
Okay, great. Since Mr. Kangas brought up those other cases, there has been investigations, and there is, we will supplement the record with the sworn statements under oath as to the improprieties of
Let
the
me just
low courts.
interrupt you. Aren't we going a little bit far afield from the
No,
issue in this appeal?
well, the issue in this appeal is so important because no, you don't lose on the homestead argument. No, you don't lose on the eviction, and no, you don't lose on the conversion. And Mr. Kangas is wrong. Article 10, Section 4 of the Florida Constitution does not allow the taking of homestead property as a sanction. And that's what was done. In re Olia, and as affirmed in other cases, the homestead property, the homestead exemption protection goes to all members of the family. That's the law. So the court has not followed the law because you cannot take homestead property, which was done. We will be supplementing with the sworn statements under oath to if this court needs to, because the law has to be followed. Only the people of the state of Florida could have arguably changed homestead protection. And Mr. Sussman was entitled to homestead protection.
Yeah, but Ms. Gaffney, your complaint alleges that the court, through Mr. Kangas, forged an order.
Yes, he did, sir.
On
There
its
is no-
face, you're accusing the court of forging an order.
No, it's Mr. Kangas
That's a
misrepresented.
legal issue that the court can consider without a hearing.
Correct. And there is no order in which there is no order that Mr. Kangas, he manufactured an order that does not exist. He's put it in his documents and he's put it in other court documents, and it does not exist. So yes, that is true. The probate court order only allowed him to go after the assets of the
Well,
estate, not the
But
homestead property.
Judge Cook can take judicial notice of the orders of the Hillsborough County 13th Judicial Circuit, can she not?
Yes, and if she
Especially
had,
when you allege that they're forged.
because Mr. Kangas, the order that you're talking about, sir, does not
No,
exist.
you alleged it.
Yeah,
I'm just trying to figure out why.
because he sits there and says there is an order that doesn't exist, and that order does not exist. He is maintained that there is an order that allows him to go after the homestead property that was purchased from Mr. Gaffney. And there is no such order. The order states, and we will supplement that with the sworn statements under oath that show Mr. Kangas's behavior, that if they were to go after the assets of the estate as described in the will of Mr. Gaffney, and the assets of the estate were the assets stolen by the clients of Mr. Kangas and Mr. Bowman. And that is what the order says. They are going to go after the assets of the estate, not the
And
homestead property.
the theft would be Christ the King Church?
No,
the-
Christ the
the
King
thief?
did not steal it.
Okay, well, if you're asking the court to take judicial notice of other orders, there is an order that your father or whoever owned the property bequeathed it or left it to the church, correct?
No, that
That's
is
an
not correct.
allegation.
That is not correct. The property was purchased prior in time to the Christ the King helping my father do his will. The property was sold in May of 2009, and Christ the King helped prepare his will in June of 2009, a month later. So no, it wasn't. The property was a life estate deed, and this court has said in Sun Trust versus Boren that a life estate deed is not an asset of the estate. But if you go back to the will, if you want to bring that up, and we can supplement this court with it, the will is very clear that the assets of the estates of the property taken by Mr. Bowman and Mr. Kangas' clients, the disinherited daughters of Mr. Gaffney, they stole approximately $1 million from him, and that has all been in the record. So that is the problem that he wants to bring up this, but that doesn't solve the issue of today. Today is there was no due process. There was never any due process. There has never been a day in court. We've never had the due process has been lacking through all these cases. You get to have witnesses an opportunity to testify, and that has not happened. And that is the issue here. And no, it wasn't 10 hours. It was 6:40 a.m. when Mr. Kangas sends the email, and the Judge Cook, I think she ruled at 11:20. That's 5 hours. That is not due process. And there should have been a hearing because homestead is really important. And this court the Florida Supreme Court has been very clear that you have to follow the law. So taking homestead property in violation of Article 10, Section 4 violates the cases that are coming out of the Florida Supreme Court, which says you have to follow what the Constitution says. The Constitution says the homestead property cannot be taken. And that is what this court has not ruled on yet. And there has been no due process, and there's been no hearing. And the only hearing that there was on homestead said it was the homestead property of Sarah Sussman. And there has no ruling to the contrary. So therefore, the homestead property was taken as a sanction, and therefore this case should never have been dismissed, and we should have had the ability to take it in front of a judge.
I need to thank you for your presentation as the time has expired.
Wow, 5 minutes goes fast.
It does. You're actually at 5.5, but I didn't want to stop you. You seem to be on a roll there. I wanted you to conclude your remark before I
thank you.
paused.
Thank you, Your Honors.
Thank you both. Please stay well in these interesting times of ours.